can do, we can, once we complete one of the part, if you have any question, then I can take up the question, right?
Yeah, sure.
Okay, ma'am.
All
Okay,
right,
ma'am.
all right. So we start with the intellectual property. What is an intellectual property? So intellectual property, it is an intangible form of property that originates from human intellect and creativity. So when we talk about IPR, we say it is intangible form. It is not a kind of a physical property we have. It is a property which deals with the creativity, which deals with the expression, which deals with your intellect. And that is why this is known as the intangible form of property that originates from human intellect and creativity. And it is a product of human creation, such as inventions, literary and artistic works, designs, symbols, names, and images. So this is a part of the intellectual property. And when we talk about intellectual property rights, these are the legal rights granted by the government to individuals or entities. If I talk about individual, it can be a natural person like me, or entity to a company, which can be a small entity, a small company, or a large company, for their original creations, including inventions, literary and artistic creations, designs, symbols, names, or images used in commerce. These rights provide creators with the exclusive control over use, sale, and distribution of their creations for a specific period, safeguarding them from unauthorized use and promoting innovation by recognizing and rewarding creative efforts. So when we talk about IPR, so it's not only about most of the like the people in India, because I go to a lot of companies, I go to a lot of universities, they think that when we talk about IPR, it totally deals with engineering domain or with the pharmacy domain. It's not so. Even student who is a part of any course in humanities can go for filing the intellectual property rights, like the artistic creation, any kind of expression, any poem, any design, or a symbol that can also be protected under the intellectual property rights. And when we talk about intellectual property rights, it's not only patents. It includes trademarks, it includes copyrights, and this is what we will be studying in the future slides, in the next slides, right? Now, if I talk about IPR, and the administration of IPR in India. This is administered by Controller General of Patents, Designs and Trademarks. In short, it is CGPDTM. And any one of you can tell who is the Controller General of Patents right now? What is the name of the Controller General of Patents, Designs and Trademarks? So his name is Dr. Unnat Pandit. He has his office in Delhi and in Bombay. And the key legislations which we will be studying are Patent Act 1970. You need to memorize the years, amended in 2005. Copyright Act, this is 1957. Trademark Act 1999. Geographical Indication of Goods, Registration and Protection Act 1999. Design Act 2000. So you can get a question on as an MCQ, as a multiple choice question where like you need to memorize the names, like memorize the names and the years, like Copyright Act 1957, Trademark Act 1999, GI Act, which is 1999, Design Act 2000. And for this particular exam, that is patent agent exam, we will be touching on what copyright and trademark is, and what GI is, and our most of the lectures, the future classes will be confined on the Patent Act 1970 and Design Act 2000. So these are the types of IPR. Uh, uh, First is patent. So type of intellectual creations protected by IPR. So this is a briefly about like the types of intellectual property rights. We have patents, copyrights, trademarks, designs, GIs, trade secret, plant variety protection, semiconductor integrated circuit layout design. So these all include to be a part of the intellectual property rights. So it's not only patents, because I've seen most of the people saying that I want to go for IP filing. And for them, the IP filing means only the patents, right? But IP filing includes, we have the eight kinds of IPR, which is patents, copyright, trademark, design, GI, trade secret, plant variety protection, semiconductor integrated circuit, layout design, right? Now, talking about patent, so it is new invention or a discovery, which can be a product or a process which is novel, it is unique, non-obvious, and industrially applicable. So, for a patent to be filed, it should be a new invention or a discovery, which is unique, which is not obvious, and which has any kind of industrial applicability. We cannot file any product which is unique and non-obvious, but it does not have any kind of work. It does not have any kind of applicability with regard to the working of the invention, right? So the examples are the drug formulation, the machinery, uh, chemical processes, any medical device, and we will be so it's a brief introduction right now, and we will be discussing everything, right? And governing IP law in India, it is the Patent Act 1970, which is amended in 2005. Talking about copyright, it is original literary, dramatic work, musical, artistic work, cinematographic films, sound recording, software. So a computer program which is a simple program, it is copyrighted. But if a computer program, it is a part of any machine, like a drone using a computer program, then it can be patented along with the device. Otherwise, a simple computer program, a simple software, it is always copyrighted. Like app, it is the application, computer application, it is copyrighted. And in the copyright, we need to give the source code and the object code to be copyrighted, right? And the examples are books, movies, paintings, software codes. So these are copyrighted. And the IP law, the governing IP law, it is Copyright Act 1957. Talking about the trademarks, we have distinctive signs, symbols, words, or logos used to identify and distinguish goods or services, like the Nike logo, Adidas logo, Apple logo. So these are trademark, my company logo. So these all are trademark, right? And examples are Tata, Reliance, the logos of Tata, Reliance, Amul logo, and then even the Airtel jingle. It is the music of Airtel that is also trademarked under the Trademark Act 1999. Next is the design. Design, it refers to any aesthetic shape. That is, it does not refer to any process. It is the shape of the product. So we can get the patenting on the shape of the product. For example, the shape of a Coca-Cola bottle. So that is design patented. Any ornament, any article in the sense any product, it can be design patented. And the examples are the bottle shape, smartphone design, furniture look under the Design Act 2000. Then the GIs or the geographical indications. These are the products originating from a geographical region within with the qualities linked to that place. For example, in Punjab, we have two GIs. One is Fulkari. Fulkari, a, it's a kind of what I can say, it's a kind of cover or a dupatta which we take, right? And then rice. Rice is another GI, which is a famous product of Punjab, right? In Darjeeling, the Darjeeling tea, that is a GI. Mysore silk is a GI. Banarsi saris are a GI. Then Kannauj Itar is a GI. And this is the governing IP law in India. It is the Geographical Indication of Goods Act 1999, right? So next type of IPR, it is a trade secret. So the best example is the Coca-Cola formula, any customer list, right? So that can be trade secret. That is undisclosed business information giving the competitive edge. Any kind of formula, any kind of, process, which we do not want that uh, the public should know, right? So giving a business information a competitive edge, that can be trade secret. The protection may be done in form of confidentiality agreement. So NDA is signed, non-disclosure agreement is signed between two companies when they go for selling the same product, like selling Coca-Cola. So the NDA or the non-confidential confidentiality agreement is signed. The confidentiality non-disclosure agreement is signed, sorry, for a trade secret. And this is not governed by any separate IP law, but protected under contract law, equity, and common law principles, right? Then we have the plant variety protection. So plant variety protection, it is like this is basically for the farmers where you go for like uh, breeding a new kind of a plant for the farmers. Basically, this plant variety protection is there. New, distinct, uniform, and stable plant varieties, new form of a mango, new form of a rose. So that can be protected under the plant variety protection. Example is new rice, wheat, or cotton variety developed through breeding. And governing IP law in India, it is a Protection of Plant Varieties and Farmer Rights Act 2001. Then is the Semiconductor Integrated Circuit Layout Design. The original layout design of integrated circuits. So examples are microchip and processor layouts. And if I talk about, we have one company, I think the name is Sankalp, which is preparing the semiconductor design in India. Then example of microchip and processor layouts. Governing IP, ISRO is also preparing the semiconductor integrated chips in India. The Semiconductor Integrated Circuit Layout Design Act 2000. So these are the types of IPR: patent, copyright, trademark, design, geographical indication, trade secret, PVP, that is plant variety protection, semiconductor integrated circuit layout design. And you can get an MCQ koi question which is related to this will be like the governing IP laws, can be any kind of example given to you. The kind of IPR, you just have to tell about like the Coca-Cola formula, what is it? Which kind of IPR it is. So it is a trade secret. Any new rice, so it comes under the plant variety protection. Is it clear to everyone?
Right till now, it is clear, ma'am.
Okay, all right. Next is the historical background and evolution of IP laws in India. This is not so important with respect to the questions which come into the examination, but yes, you need to have a clear understanding of the early legislation. Then next is like consolidation under Patents and Design Act, like what happened in 1945, what happened in 1930, post-independence reforms. Just a brief idea about it, so that if any MCQ comes, you can just fill it. So first is the early legislation. I have simplified this and I'll be sharing this PPT with you. Early legislation, that is a British era in 1856. The first legislation in India relating to patents was Act 6 of 1856. And what was the objective of this legislation was to encourage inventions of new and useful manufacturers and to induce inventors to disclose the secret of their invention. 1857, the act was repealed by Act 9 of 1857 due to lack of British Crown's approval. So just memorize the year 1857. What happened? Act was repealed by Act 9 of 1857 due to lack of British Crown's approval. Then in 1859, then Act 15 of 1859 introduced. And what was Act 15 of 1859? Granted exclusive privileges only for useful inventions. So there were certain privileges for useful inventions, and priority period of up to 12 months was given to the under this act, which was 1859. Now, when I talk about the priority period, so any one of you can tell me what do you understand and what do you figure out what can be the priority period?
From the date of filing.
Yeah. So priority period, it starts from the date of filing, and we have a window of 12 months in which you can submit a complete specification, you can submit a complete application, first thing. Second thing is, if you have filed the application today, you have 12 months to file that same application in other countries, and you will be given the priority date as of today. So you have a 12-month window. That is the that is the priority period. And in 1859, that was the extended priority period to 12 months. In 1872, consolidated into the Patents and Design Protection Act to include designs. Then 1883 and 1888, amendments to align Indian law with UK law, protecting novelty and exhibition disclosures. So you just need to memorize the years and what happened in that year, like 1883 and 1888 amendments to align Indian law with UK law. It's not like being used right now, so that is why I'm not into a lot of explanation for this. You just need to memorize the year and what happened in that year. So this was the early legislation, British era. Then in 1911, the Indian Patent and Design Act 1911 replaced all the previous acts. So in 1911, all the previous acts, they were repealed. The act brought patent administration under the management of controller of patents for the first time. So it was in 1911, there was a term controller of patents, and the act brought patent administration. All the patent administration was under the management of controller of patents for the first time, and this happened in 1911. 1920, priority rights with the foreign countries. So the priority window for 12 months, which was for the national filing, that was also available for with the foreign countries, right? 1930, provisions for secret patents, government use, rectification of register, and term extension for 14 years to 16 years. So we will be uh, discussing about the patents which are used by the government. We will be discussing about the rectification of register and the term extension. That is a patent term extension from 14 years to 16 years. And right now, the term of patent is, what is the term of patent right now?
10 years. Oh, no, not 10 years. Patent. Trademark is 10 years.
20
Yeah, for
years.
patent, 20 years. It's 20 years, right? And in 1945, introduced filing of provisional specifications and 9-month deadline for complete specification. So it was in 1945, there was a filing of the provisional specification that was introduced. And we can file a patent in two ways, either filing a complete specification, that is either filing a complete application at one time, or filing a provisional specification first, and then you have 12 months of window where you can complete the application and then file a complete specification. Right now, the deadline is 12 months between provisional specification and complete specification. The time period, it is 12 months. We have a 12-month of window where we can file a complete specification, right? Now, next we have the post-independence reforms. In 1949, after independence, it was felt that Indian Patent and Design Act 1911 was not fulfilling its objective. It was found desirable to enact comprehensive patent law owing to substantial changes in political and economic conditions of the country. So that was in 1949. After independence, a committee was constituted under chairmanship of Justice Dr. Bakshi Tek Chand, a retired judge of Lahore High Court, in 1949 to review the patent law in India in order to ensure that patent system is conducive to the national interest. So a committee was formed in 1949 after independence under the chairmanship of Justice Dr. Bakshi Tek Chand, right? And a review was done for the patent law in India to ensure that patent system is conducive to the national interest. It supports the national interest. And the following uh, so the committee it recommended the following reforms to prevent abuse of patent rights and suggested compulsory licensing for food, medicines, and essential devices. You need to memorize this. That Justice Bakshi Tekchand committee recommended reforms to prevent abuse of patent rights, first thing, and suggested compulsory licensing for food, medicines, and essential devices. And this happened in 1949. 1950 and 1952, amendments to enforce compulsory licensing and public interest provisions. I'm not going to explain compulsory licensing right now because we have the section 84 where we will be discussing about the compulsory licensing. So just right now, it's amendments to enforce the compulsory licensing and public interest provisions. And for the time being, you can just memorize it. And during the section 84, I will be explaining you about the compulsory licensing because that is where you will be able to understand about compulsory licensing, right? So next is the Rajagopala Iyengar Committee and Major Reform. In 1957, the committee was formed, submitted its report in 1959, recommended retaining patent system, but with major reforms and formed the basis of Patent Bill 1965, which lapsed. So in 1957, you need to memorize this. A committee was formed, submitted its report in 1959, recommended retaining patent system, but with major reforms and formed the basis of Patent Bill 1965, which lapsed. In 1967, revised bill introduced referred to the Joint Parliamentary Committee. In 1970, enactment of Patent Act 1970. Repealed 1911 Act for Patents. However, 1911 Act continued to be applicable to the designs. So in 1970, the Patent Act was enacted, which was repealed, and 1911 Act for Patents was repealed. However, 1911 Act continued to be applicable to the designs, right? In 1972, most provisions of 1970 Act came into force on 20th April 1972 with publication of Patent Rules 1972. So patent rules are the rules as to how we operate the different sections, as to how we use the different sections. They are the patent rules, right? So this is the historical background and evolution of IP laws in India, starting from early legislation, that is the British era, 1856, 1857, 1859, 1872, 1883, and 1888. Then consolidation under Patents and Design Act, 1911. 1920, 1930, 1945, introducing filing of provisional specification and 9-month deadline. Then there's 19 post-independence reforms, which started in 1949. And then a committee was constituted under the chairmanship of Justice Dr. Bakshi Tekchand. And the reforms to prevent abuse of patent rights and compulsory licensing of food, medicines, and essential devices was suggested. For the time being, you can just memorize the compulsory licensing, which will be explained during the section whenever we will be taking the section. And then Rajagopala Iyengar Committee and Major Reforms. And 1972, most provisions of 1970 Act came into force on 20th April 1972 with publication of Patent Rules 1972. Are we okay till here?
Yeah, till here it's fine, ma'am.
Okay. So next we will be starting with the before starting with the sections, this is the brief introduction. I'm just touching the points, and today the most of the part will be introducing you to the different terms, so that whenever we use these terms during our discussion of Patent Act, discussion of patent rules, Design Act, design rules, you are familiar with the terms. Another uh, another reason why I have included these points as a part of our first class are because these points were a part of the MCQs during the last 2 years. So I want you to memorize these words so that whenever you have, because directly some of the some of the points which we will be discussing today, they are not a part of the Patent Act and patent rules. But we in last 2 years we had some MCQs related to these points, and that is why I'm discussing these points over here, right? Okay, we'll be starting with the TRIPS agreement. And this agreement, the full form of TRIPS, it is trade related aspects of intellectual property rights. So you need to know the full form of TRIPS, which is trade related aspects of the intellectual property rights. Now, this agreement, while recognizing that IPR are private rights, establishes minimum standards of protection that each government has to give to the intellectual property right in each of the WTO member countries. The member countries are, however, free to provide higher standards of intellectual property rights protection. So basically, this right under the TRIPS agreement, the IPR is covered. And when we talk about IPR, internationally, the copyrights and related rights, trademarks, GIs, industrial design, patents, layouts of integrated circuits, protection of any undisclosed information, that is the trade secrets, are covered. When we say that these rights give us the protection in the international countries, this means that India is a member of the TRIPS agreement, where any country which is a member of TRIPS agreement, we are free to use the copyright, trademark, GI, industrial design, and we are free to get our patent registered, patent protected in that country. We are free to protect our layout design of integrated circuit, and we are free to protect the undisclosed information, that is a trade secret, in that country which is a member of the TRIPS agreement. So the agreement, while recognizing that intellectual property rights are private rights, establishes minimum standards of protection that each government has to give to the intellectual property right. Each government means the countries which are a part of the TRIPS agreement, which are the part of the World Trade Organization. The member countries are, however, free to provide higher standards of intellectual property rights protection. The TRIPS agreement is, by its coverage, the most comprehensive international instrument on IPR, dealing with all types of IPR with the sole exception of breeder's right. So the sole exception is uh, the breeder's right, that is the farmer rights. IPRs covered under the TRIPS agreement are copyrights and related rights. They can be protected internationally. Trademarks, GIs, industrial designs can be protected. Patents, layout design of integrated circuits, protection of undisclosed information. This can be protected internationally. Now, the TRIPS agreement, it is based on the basic principle of other WTO agreements like non-discrimination clauses, national treatment and most favored nation treatment, and are intended to promote technological innovation and transfer and dissemination. The basic purpose of TRIPS agreement is to promote the technological innovation and transfer and dissemination of technology, irrespective of the country, right? So if any, for example, I am the one working on drone technology, and if I develop a drone which is a kind of a drone which is not available in other countries, then my drone, my product can be protected in other countries. So under this TRIPS agreement, I can promote a technological innovation. My drone, the product, it will be protected. It can be, and the technology, it can be transferred and disseminated to any country, to any region which is a part of the TRIPS agreement, right? It also recognizes the special needs of least developed country members in respect of providing maximum flexibility in domestic implementation of laws and regulations. So all the countries under the TRIPS agreement have the right to promote technological innovation, have the right for the transfer and dissemination of the technology, right?
Excuse me, madam.
Yeah.
Hello. Madam, I
Yes.
have a question actually.
Yeah.
One drone is patented in, for example, China. Okay,
Yeah.
madam. I'm doing some modification, and can I file a patent in India, madam? Actually,
So patent is a territorial right. And if your drone has something novel, which is though patent is a territorial right, so if you have the protection in India, this doesn't mean that you have a protection in China.
okay, madam. For example, you can assume, madam. Actually,
Yeah,
so I am controlling a drone through Wi-Fi.
yeah,
I think Wi-Fi is some limited range. Okay, so I can understand. But for example, I'm telling. So I'm
yeah.
inventing a drone which can be controlled through Wi-Fi. Okay.
Okay.
Can I file it? Can I file a patent for it?
Just for the invention that you have a drone which is working on Wi-Fi.
Oh, yes, madam. That's what I'm asking.
So if you have any drone, uh, which for example, you have a drone. So what is the use of the drone which is working on Wi-Fi?
No, no. For example, I'm telling, madam. For example, just you assume that 1 kilometer actually. So I can send
Yeah,
the drone to 1 kilometer or something like that. I can control
yeah.
the drone through Wi-Fi. Can I
Okay.
file a patent of this?
I'll tell you. So I'll give you a simple example of that. For example, and adding to what you have said, I think you are talking about a logistic drone. Now, for
Yes, madam.
example,
Yes, ma'am.
you have a drone which can
Okay,
cover a range of 1 kilometers, which you said,
okay, ma'am.
and it now it has to serve a specific purpose. For example, the drone is used for the pesticide spray, or the drone
Yeah,
is
yes,
used
madam.
for the transfer of medicine, right?
Okay,
So it
madam.
is give
Okay, so
right. So it is a drone which is being made for the benefit of the community. It is a drone which has the industrial applicability. And in case the same drone does not exist in the market, right? And it has certain specifications. For example, it is a low cost drone, it is a lightweight drone, and
okay,
the
madam.
the weight of your drone, it is less than the weight of the drone which is already existing into the market, then you can get it patented,
Okay, madam. Okay, okay, I can understand.
right?
Thank you.
Do you have any other
Okay.
question?
No, madam.
Okay, all right. So talking about TRIPS agreement, the TRIPS agreement is based on a basic principle of other that I have already informed you that basically the TRIPS agreement, when signed by different countries, is to promote the technological innovation and transfer and dissemination of technology, and to protect the various IP rights, which includes the trademarks, copyrights, the patents, and the designs, they all are the part of the TRIPS agreement, right? Now, post TRIPS, trade related aspects of intellectual property rights amendment. So, what are the post TRIPS amendments? In 1995, India joined WTO, World Trade Organization, and became the TRIPS compliant. You need to memorize the year 1995 when India joined. India is a founding member of TRIPS when TRIPS was formed. In 1999, the Patent Amendment Act 1999 enabled filing of product patent applications, especially for pharma and agrochemicals, but postponed examination. Such applications were to be examined only after 31/12/2004. Meanwhile, the applicants could be allowed exclusive marketing rights to sell or distribute these products in India, subject to fulfillment of certain conditions. So these are the amendments which happened after TRIPS. First thing, 1995, India joined WTO and became TRIPS compliant, was a part of TRIPS. Then in 1999, there was Patent Amendment Act in 1999. And what was the amendment? It enabled the filing of product patent applications, and especially for pharma and for agrochemicals. But at that time, postponed the examination. Such examinations were to be examined only after 31st December 2004. Meanwhile, the applicants could be allowed exclusive marketing rights. What are the exclusive marketing rights? They were allowed to sell or distribute the products in India, subject to the fulfillment of certain conditions. And we will be learning about the conditions in the next classes. Then in 2002, Patent Amendment Act 2002 was introduced, which introduced significant changes and replaced Patent Rules 1972 with Patent Rules 2003. Then in 2005, Patent Amendment Act 2005 came into force from 1st of January 2005, which allowed patent products in pharmaceuticals and agrochemicals in compliance with TRIPS. So these are some of the addition post TRIPS. These are some of the amendments after 1995, and you need to memorize them. So starting from 1995, India joined WTO and became TRIPS compliant. In 1999, Patent Amendment Act 1999, which enabled filing of product patent applications, especially for pharma and agrochemicals, but postponed examination. And it was the examination was postponed after 31/12/2004. But the applicants were allowed for selling or distributing the products in India, subject to fulfillment of certain conditions. In 2002, then the Patent Act 2002 was introduced. Significant changes and replaced the Patent Rule 1972 with Patent Rule 2003, which happened in 2002. In 2005, Patent Amendment Act 2005 came into force from 1st of January 2005, which allowed product patents in pharmaceutical and agrochemicals in compliance with TRIPS. So if the question comes that when were pharmaceutical and agrochemical products patented, that was in 2005, right?
Excuse me,
Now,
madam.
yes. So,
Madam,
yes,
can you
sir.
explain the second point once again, madam?
Yeah.
What is
So,
the 3112, madam? Actually, 31/12/2004.
yeah. So what happened in 1995, we were the member of TRIPS, talking about India.
Okay, madam. That's
Now
okay,
in
madam. Second point.
Yeah, now in 1999, there was the Patent Amendment Act 1999. Now it enabled filing of product patent applications. So the Patent Act had a provision which enabled the filing of product patent applications, right? It
Especially
had a
for
provision of,
uh, pharma and agrochemical product, madam.
yeah,
Am I right,
for
madam?
pharma, for agrochemicals, like you have developed a organic pesticide, or you developed any
Okay.
drug formulation, right? But the examination part was postponed. It was not a part of
Mm.
that Patent Amendment Act. And the applications were examined only after 31/12/2004, for the reason the pharma and agrochemicals, initially the products were not allowed to be a part of a patent application, right?
Okay.
So,
Okay.
but there was a clause where the applicants, if they are developing any product, they were allowed
Okay,
to
madam.
sell or distribute the product in India,
Okay,
right?
okay, madam. But no exam was conducted till
No examination was conducted.
31/12/2004.
Yeah.
Okay,
Because
I
we
got
were
it. I
in
got
the
it.
Yeah, because we were in the process of making the patent rules and patent acts. Till
Okay,
date,
okay, madam.
there are
That
certain, yeah, till date, if you see, there are certain provisions which need revision. And but yes, they are a part of Patent Act. So this is what happened in 1999, where the examination was uh, like we allowed only after 31/12/2004, but there was a provision where we can sell or distribute the product, right?
yes, madam. Yes, madam. I got it, madam. Thank you, madam. Thank you.
Okay. Then next we have the patent rules. Then under the provision of Section 159 of Patent Act 1970, the central government is empowered to make rules for implementing the act and regulating the patent administration. Now we will be learning about Patent Act and then the patent rules. Now, what are the patent rules? Patent rules are the rules for implementing the act. How the act will be implemented, what the way we have, like how the operations will be performed when we have a company. So we have a operations head, how the operations will be performed. So that is the patent rules, the rules for implementing the Patent Act and regulating the patent administration. Now, accordingly, the patent rules 1972 were notified and brought into force with effect from 24 1972. You need to memorize the date, right? These rules were amended from time to time till 20th May 2003, when new patent rules 2003 were brought into force by replacing the 1972 rules. So 1972 rules were replaced by patent rules 2003. These rules were further amended by Patent Amendment Rules 2005 and the Patent Amendment Rules 2006. The last amendments are made effective from 5th May 2006. You need to memorize the dates. So section, which was the provision of Section 159 of Patent Act 1970. And why are the rules made? For implementing the act and regulating the patent administration. And the patent rule 1972 were not notified and brought into force. You need to memorize the date. That is 20th of April 1972. These rules were amended till 20th May 2003, when new patent rules 2003 were brought into force by replacing the 1972 rules. Then these rules were further amended by Patent Rules 2005 and the Patent Rules 2006. The last amendments are made effective from 5th May 2006. You need to memorize the dates, right? So this is a brief overview of major amendments to the Indian patent rules. This is a simplified form, and I would suggest whosoever is attending the class that when you have 1 week of your examination left, just go through the brief overviews of the dates, the timeline, and the impact which that key amendment has created, right? So a brief overview of major amendments to the Indian patent rules. These are the major amendments to the Indian patent rules. So year of amendment is 1972. Introduced rules under the Patent Act 1970, and the impact was created the foundation for patent filing, grant, and administration. How the patent will be filed, how the patent will be granted, and what all things we need to take care that are introduced under the Patent Act 1970, right? Then 2003 replaced 1972 rules, enabled e-filing. So e-filing, it was enabled in 2003. So impact was modernized and digitized the Indian patent system. So modern forms, we have 32 forms right now. We will be discussing about them. Enabled e-filing, that was in 2003. In 2005, allowed the product patent, revised opposition process. That is section 25. We will be doing it. Today we are just knowing the terms and the years and the major terms which will be used in the Patent Act and the patent rules. So in 2005, TRIPS compliance, important for pharma and chemicals. In 2006, Form 27 was introduced. In 2006, for the working of patents. Right now, we have to file Form 27 after every 3 years, which increased transparency and promoted digital filings. In 2016, in expedited examination for startups. So startups, they can go for the expedited examination. Even the educational institutions can go for the expedited examination. So this was introduced in 2016, faster patent processing, especially for startups and innovators. So the startups are benefited from the expedited examination. Even the innovators, they are benefited from with the expedited examination. In 2019, extended expedited exam to more applicants, to women, reduced fees for the education sector. So 80% of the fees was reduced. The fees was reduced by 80%. Initially, the patent filing cost was 8,000. Right now, the patent filing cost, it is 1,600 for a small entity. So promoted inclusive innovation and ease for academic institution and for the women entrepreneurs. In 2020, simplified Form 27. So Form 27, the submission was once a year for multiple patents, but right now it is once in 3 years. The Form 27 needs to be submitted. Reduced compliance burden on patents. So obviously the documentation was reduced. In 2021, recognized educational institutions as a separate category with reduced fees. So right now the educational institution, they the filing, it is very simple for them with a very much reduced fees that happened in 2021, which encouraged research and patent filings by the academic bodies. In 2024, so request for examination deadline, it is reduced to 31 months. Earlier, it was 48 months. Form 3, it is simplified. So the Form 3, we'll be discussing about the Form 3, which is statement and undertaking. That is simplified. Grace period allowed, which is Form 31. So 12-month grace period for filing a patent application after a public disclosure of invention, which is a part of Section 31 of Patent Act. So that is allowed. Form 27, now it can be filed once every 3 years. And the filing of divisional application from the provisional specification allowed. So filing of divisional application means for one patent, in one patent, we can file another application, which is a divisional application. We will discuss about that. And then an inventor can get a certificate under Form 8A. We will be discussing all these terms, and there is a time-bound opposition process. So these are the amendments which are done in 2024. The major amendment is that the request for examination deadline, it is reduced to 31 months. Earlier, it was 48 months. So there is the patent process. It is very much simplified right now. So these are the major amendments to the Indian patent rules. You need to memorize them. We can get a question from these from this table. So starting from 1972, introduced rules under the Patent Act 1970, created the foundation for patent filing, grant and administration. 2003, replaced 1972 rules. E-filing 2005 allowed product patents. Then 2006, Form 27 was introduced. Digital signature filing was introduced. Then 2016, expedited examination for startups, e-filing, video hearing, web conferencing hearings, right now, which is going on. In 2019, extended expedited exam to more applicants, women entrepreneurs, reduced fees for education sector. 2020, simplified Form 27, submission once a year. That was in 2020. 2021, recognized educational institution as a separate category. Then 2024 RFE's request for examination deadline reduced to 31 months. Earlier it was 48 months. Form 3 is simplified, which is Form 3. It is for statement and undertaking for the foreign filing, which is to be submitted for the every patent application. Grace period allowed. So 12 month of grace period for filing a patent application after a public disclosure of invention. This is under Section 31 of Patent Act, that is allowed. Inventor certificate. Inventor can get a certificate under Form 8A. We will discuss about what an applicant is and what an inventor is. Filing of divisional application from provisional specification allowed. Time bound. We have a time bound opposition process. And then 2025, this is not in force yet, and but we can discuss about it. You can get a question from this. So introduced adjudication for offences via Jan Vishwas Act. Now this Jan Vishwas Act, it provides a system of administrative adjudication for certain minor offences, thereby so we have this adjudicating officers. They will be appointed and they can take decision to impose penalties. So controller generally takes the decision for imposing the penalties through inquiries and decision, thereby reducing the burden on the judicial system, and there will be a faster resolution of the minor cases of penalties or for patent infringement. Then introduce the electronic complaint Form 32 and Form 33. So these are two new forms which are introduced. Form 32, this is introduced, we will be doing under section 120, 122 and 123. 20,000 is the fee for Form 32. And then we have Form 33, which is for the appeal. Then digital communication and penalty structure, higher fines for non-compliance, unauthorized patent claims, it is 10 lakh plus rupees 1,000 per day. Failure to furnish the information up to 1 lakh. Fine. For the false information, it is minimum 25 lakhs. We will be discussing all these in the patent sections, in the Patent Act. Then penalty for unauthorized practice by a non-registered patent agent. So if any non-registered patent agent is filing patent for other inventors, so there is a fine of INR 5 lakh plus rupees 1,000 per day for the ongoing offences. So this is a draft patent amendment rule 2025, and this is not enforced yet. And the impact is streamlined enforcement and introduce civil penalties instead of the criminal prosecution.